I know him, I see him in the community like I see a lot of people in the community. I don't socialize with him, and if I recollect once, we went on a fishing trip with a group of about 8 people, and that was probably 3 or 4 years ago. But I haven't socialized with him since. I've never represented him, and I think that should be the end of that.
Mr. Crokin, I was going to address that when we got to number 7 to actually make the decision. I haven't had a lot of time to look at this, but I am pretty familiar with ethics rules when it has to do with public officials and their duties to carry out their functions.
Mr. Chairman.
If I could, please. I'd like to explain this. I'd like to kind of frame out the way we should look at this. It might answer your question before you ask it.
I got it.
Okay. You will have a duty to go forward. Before any decision would be made on any hearing in this matter, there would have to be, I would ask the board 2 questions. Do any of you have any information that you haven't heard here that would affect your ability to give an unbiased determination? And you have to answer that, yes or no. The other thing you're asked is, do you have any personal interest in this matter that would influence your decision in this matter? And if you answer that no, you proceed. There's a case, believe it or not, came out of Hortonville that has to do with the importance of officials in elected positions carrying out their functions to the best of their abilities. And even when there does appear to be a conflict, if it could be said there is a conflict. So it is left to the individual to determine whether they have a conflict to begin with. And in a situation like that, I would be asking Mr. Croak if he feels it would affect his ability to be impartial. With regard to Ms. Olson, I see that's also referred to here. She's a Health and Human Service Director, and there's an allegation that she is a direct report. Apparently her department is in the committee that is chaired by Mr. Gavarski? No?
No. Franny and I both have the same position on that. We're just board members.
Okay. And,
I
okay,
think
so
that-
you did,
I might be vice chair. I'm not sure, but chairman is Jack. He takes
Chairman
care.
is Supervisor Allen, but I believe you are vice chair.
I think so, yeah.
well, it strikes me in regard to that the objects of the complaint are both board members too, so the same could be said on the other side, that there's a reason that you would be pressured to, because you have 2 supervisors who could be, who are alleged in the complaint, and you have 1 supervisor on the other side. You're kind of between a rock and a hard place, but it's on both sides. So I don't know that there's an ethics issue with that. Again, if you feel that's going to affect your ability to be impartial, you really should tell the board and not proceed. But if you think you can be impartial, you're in the position to proceed. So those are the 2 concerns that are raised with regard to potential bias. The other 2 having to do with who co-signed is that who notarized? Ms. Hyder's affidavit refers to James Gavarski as complained. Is there a concern that there was an error on who was referred to? I think we addressed that at the last meeting and noted a correction that it was Mr. Gavarski, his name happened to be wrong on there. And then the complaint should have been filed, shall be filed with the city clerk, and the city clerk shall forward it. I have to look into that a little further. I don't know the details of that right now. I'm not exactly sure where it was filed. Nor am I real sure I would understand how that would bias someone, but so long as it eventually got to this board properly. But I will certainly look into that. So I'm a little ahead of where I wanted to be, but I think we've just addressed
We get back to
concerns that were.
Mr. Gavarski's.
Now, Mr. Gavarski, if you don't mind, I just wanted to finish my babbling before we.
That's fine. I would like nothing better to have this go away. I'm mean, I have no vendetta against these, but there's one issue here, I think, that has been missed and bypassed. And I think the premise of this whole thing was because of that. At our board meeting, we were directed by lawyers to not discuss this with anyone, including ourselves. It is quite clear that that was compromised. That should be addressed not only when it appeared and what was appeared and so forth, but these were directives from lawyers. That, I think, is probably more the basis of this than anything else, in my opinion.
Well, and you're the complainant, so your opinion's important in that regard. So that, the intent was to address the fact that there was a directive that may have been violated, not simply that the information got out. The board should be aware of that.
Could I answer Bob about that? You know, I went to the fair that afternoon, and I did not see a thing on TV. But I went to the fair about 4 o'clock, and everybody I saw was coming up and asking me, what was this on the news? What was this on the news? So, I mean, I had the same thought in my head, what is going on here that we were directed to stay silent, a gag order, and all of a sudden everybody in the county but me knew what was going on. So I kind of had I mean, what is going on? Is this open? Can we talk about it now? What is? I was very confused at the time.
I guess I would ask, what did you ultimately decide?
What did I ultimately
Yeah.
decide? I just told everybody I didn't know what was going on because I hadn't seen the news, and I let it go at that.
Okay.
And I never did see it on the news.
But you hadn't been at the board meeting where it was told you shouldn't discuss this?
Oh, yes, I was.
Oh, you were, okay.
Certainly.
Well, again, the question, we're not at the hearing stage at this point in time. The question is, do you think there's enough questions going around here, based on your own conversations, that you should schedule this matter for hearing and clarify?
Just in addition to the October 11th letter that you just referenced, I'll throw this out there now so it doesn't become an issue at our next meeting, well, which is a non-issue, but I'll point out the fact that Supervisor Kowarski chairs my oversight committee. Mr. Bork is also on my oversight committee. I do not feel that is in any way influences my decision, so I just want record of saying that.
So again, you have, the question is there probable cause to believe that the respondents violated any provisions of the provisions as alleged in the complaint, to the extent that the board should indicate which charges they find there is probable cause for and schedule for a hearing. If you don't believe there's a probable cause for any of those three violations, they should say so. And either investigate further if you think you need more information before you make that decision, or dismiss it.
So getting back to Mr. Kowarski and Mr. Fuller's observations, the really question is, was someone instructed not to discuss this, not to disclose it? And did they discuss it and disclose it? So the news is out August 10th, but the news media wasn't instructed not to disclose it. I don't know how they got their information, somehow they always get their information. But the question is, were all the members of the county board instructed not to discuss it, not to disclose it? That's the question. I agree with that. And I think that's what we should narrow this down to. We can't do anything about the media. And I don't think whether it was released in the media or released through the grapevine or the rumor mill or whatever sources are out there, I think the question is, was the directive to not disclose, not discuss, was that violated? That to me is the only question.
And we are in possession of, although I don't have a transcript of it right now, I could get one for you, of a statement made by Mindy, what's Mindy's last name? Dale. Why can't I think of it? I've only known her for 30 years. By Mindy Dale about at that board meeting. Again, I see that more as evidence. I think we're starting to really try this case, as opposed just to determine, is there enough here to think, should we look into this, should we have the hearing? But I don't know that taking this complaint on its face as true, and stated that they were told not to discuss it. And the question also will become, not discuss what, when we get into it. But it strikes me you're now starting to really get into the merits, the actual evidence of what happened here, as opposed to the framework. What are we talking about?
Well, there's-
And do you think that this might have happened?
If you look at paragraph 3 of the complaint, it says that Attorney Mindy Dale gives specific instruction, don't talk about it, don't discuss it, don't disclose it. If you look at paragraph 3 of the response, it admits that. So I don't think that's a question. The question is, was it disclosed? Was it discussed?
Got it?
I think that's, I'd really like to know in the end, if you find that it's been violated, what's the penalty?
That's gonna be up to you folks.
Well, I know. I think Mr. Dubarsky kind of hit it on the head. You know, he'd like to see this go away, but I don't think it's that easy.
Again, the complaint's supposed to be taken as true at this point in time. The additional information we got you is just to frame out when the information was released and generally what was released.
Well, I think if you look at the response, it says, yes, we were instructed not to discuss it, not to disclose it. And that it was disclosed in the newspaper article and the letter to the board. Of course, the board was already have it, but at least the newspaper, that letter does disclose and does discuss. I think that is in itself probable cause.
And I guess the one thing I kind of confused with is, and I was excused for that, the county board meeting that night that they had it, so I don't know what was said, but once that, when you go into closed session and you're told to keep quiet on it, at what time is that gag order essentially lifted? Is it when it becomes public knowledge, or is it when the next meeting, or how does that, when does that time elude us, go away?
And of course, that's going to vary a little bit with exactly what you're talking about. For example, in a situation where a hearing is involving an employee, I would say not until after that's disposed of should there be discussion. There's a couple issues you're gonna run into there. And again, I don't wanna get too far into the evidence on this, but there's a couple issues you're gonna have to explore if this goes forward. One is going to be what was said with regard to even that hearing. There's a couple reasons you wouldn't want to disclose anything, for example. One would be you don't want to taint the impartiality of the board by talking it over. Another one would be you don't want to get extra evidence out there. You don't want to sway the public. You don't want them taking sides. You don't want to let your insurer know about something. You don't want to give people who may sue your insurer information that may help them sue the insurer. So there's a lot of reasons you don't disclose. In this particular case, that would be a matter of proof. What was said and what was disclosed. The question is, are we at the point where this board thinks we better look into that, or aren't we? Or do we think, it's pretty clear that there's nothing that was questionable here?
What else would you look into? The minutes of the county board meeting?
Could look into,
To close
I went
session?
back and checked the minutes on the county board meeting.
Yeah.
There's nothing said at all about what went into closed session whatsoever. And we were not warned after we went back into closed session, or open session. It was all done in closed session.
well, again, we're kind of getting into the facts of things. And trying to keep this as narrow as possible. I don't want to hear the case today. based on what we know, reasonably contemporaneous with the release in the media, the other letter was released. And I think there's two questions there. Number one, is the letter different than what the media talked about? And number two, is there reason to believe that the contemporaneous disclosure somehow would have violated the direction not to disclose the information? And if you have questions about that, you think that that's something that should be reviewed, you order a hearing. If you think we're okay now, we're done.
I agree with what was said, that we were given a gag order and people violated the gag order. But again, at what point do you say it's over with and just get rid of it? I mean, I understand the confusion. And there was a lot of emotions on both sides.
Just in general terms, I mean, there are questions that I still have that I think a hearing could answer. Questions I think that probably Minnie Dale's statement could probably answer a few of those. And I'd like to allow those that are making statements as to how things transpired, the opportunity to present that with some evidence. And I think that would satisfy the intent of why we're here. I think we established a probable cause, there's questions going around as to what needs to be done, and I think a hearing is the best way to get to the bottom of everything.
Is the motion ordered to proceed to a hearing?
Yes,
Sure.
it certainly would. That's one of the things you could decide.
So moved then.
Do we need a specific motion finding probable cause to move toward a hearing?
Are you talking about all elements of the complaint in your motion? The three things that are alleged, that there's probable cause for all of those? And that the matter should be scheduled for hearing? Again, that's consistent with what you did at your last meeting.
Like I said, they'll hopefully answer any of these questions.
Right, or at least make the attempt to get to the bottom of everything.
That also, if you have a hearing, we have to give at least 30 business days notice, so that gives enough time for some response from you. I also would recommend, if you go in that direction, that you get somebody to prosecute the complaint for you. I'm not in a position to do that. I'll be advising you guys. So, but we're a little ahead of ourselves. Do we even have a second on that motion?
I'll second.
Further discussion? Be in order.
More
Okay.
discussion?
Does anybody believe they should disqualify themselves? I want to give you that opportunity at this point.
I do not.
I do not.
Okay. Then it would be appropriate to take the vote, I suppose.
All those in favor?
Aye.
Aye. Those opposed?
Opposed?
You want a roll call or you can answer that?
Roll call, let's do roll call.
Okay. Crowe?
Yes.
Baylor?
No.
Yes.
Work? Yes. And I'm a yes.
Now, moving forward to the hearing, as I put in my outline, the ethics board found probable cause exists for believing the allegations. The ethics board shall not less than 30 days after such finding schedule a hearing. So it's not less than 30 days, and frankly, the season you're running into right now, I don't know if the complainant and the respondents have a preference, but I gotta believe we probably are looking at after the Christmas holidays, or do you wanna do it before the Christmas holidays? And there's also some time that if the board determines that they wanna hire somebody to assist in the prosecution, it takes a little time to prep this, it takes a little time to prep the defense. there still is evidence that has to be presented. It's a fairly formal hearing. So